everyone, and welcome to Pod TV. I am one of the founders, Kimberly Calhoun, and it is my honor to introduce to you one of our best shows for the consumers' rights, Timeshares, Solutions or Surrender, with a host who will not give up in making things right for the consumers, Irene Parker. Everyone, help me welcome Irene Parker to our show. Irene, this is our 11th episode. I mean, here we are, May 7th. You have accomplished so much with the small amount of time that we have done this 11 episodes. And I can't wait to hear what has been happening since I've been gone.
Yes, there's never a dull moment in timeshare, and we're so happy. Our volunteers and our board of directors are so grateful for this opportunity to let people have their voices be heard. I like to, before I bring on someone that was the very first person I reached out to in 2016 after he was quoted in the New York Times by Pulitzer winner Gretchen Morgenson, calling the oral representation clause a license to lie. And so since then, I've probably talked to we estimated 3,000 timeshare members and our volunteers. But I like to start the show with a couple of calls that came in since the last show. One of them, a senior, was charged $13,000 by an entity called Encore Law, which is not a law firm, and they owned at Marriott's Harborside. Knowing Marriott and that they're one of the better companies to work with their members, there was no reason to pay $13,000 to anyone. The other person was a caller, and this is just bizarre, where she had 3 timeshares. One of them was Diamond Resorts. I've always said they've been good about taking back through transitions if you meet the 3 criteria. And she was initially sent something that said she was eligible. Her husband had a stroke and couldn't drive anymore. And then she received something saying, we are not taking them back at this time. And so then she got a call from someone that said they were working with Anthony Sabatini, who's a real person. They said running for the House of Representatives, and that there was terrible timeshare law changed in 2015 where your heirs would be liable, and you should attend this meeting. Well, after they realized something was very wrong, they contacted Mr. Sabatini, who had not heard of Consumer Protection Network. Beware of generic sounding names. So worse, they had paired her with a mediator. The mediator left the room for 30 minutes, came back and said, you've been released from all 3 timeshares, which is nonsense, of course. The other 2, one of them was Smuggler's Cove in Bradenton, Florida. And I contacted them with her on the phone, and they were horrified. They said they were going to be warning their owners. And the other one was a resort in Kentucky. They gave me the name of her attorney. The attorney said they would charge her $125, and she would have to write a $50 check. She had transferred $22,500 from her bank account to pay this entity. So fortunately, we have honest people helping people that are in trouble with timeshare, and one of them is Mike Finn. And Mike Finn has been practicing law in St. Petersburg, Florida for over 50 years. He's a member of the Florida and the Michigan bar. I wasn't even aware of the federal and American bar. There must be lots of bars. He holds real estate licenses in Michigan and Florida. He received his JD from Wayne State, which Nick told me stands for Just Depends. And he has a very solid accounting background. So we welcome Mike Finn, attorney Mike Finn, on today's show. And I have some very important questions that I've prepared. 3 of them are my questions, and the other 5 are the most common questions and posts that we hear about from posters and people reaching out through TARDA. So Mike, if you don't have anything more to add on your introduction, the most common question is what happens if I stop making my loan payments? What happens if I stop paying my maintenance fees? Will my credit be affected for one or both? And can you help me with my credit?
Thanks for the introduction, Irene, and I'm pleased to answer your questions. Let me answer the question two different ways. As a law firm, when we are hired by somebody that is interested in terminating their contract with the timeshare, one of the things that we recommend in many cases, most instances, is that they withhold payment from the resort. This creates an issue where the resort has to deal with the fact that they have a receivable that they're no longer receiving any money on it. So it creates a situation that they can't ignore. If you ask the resort nicely, can you please just take it back? I don't even want any money. Just take it back, but you continue your payments. The chances are that the resort is going to ignore you because they're collecting their money. They're perfectly happy. And therefore, that's not, you almost have to create the scenario where they have to deal with the fact that they have a non-performing receivable because that creates a business issue for them. We like to see that done with an attorney, as opposed to without an attorney, because what the resort will do when you stop making your payment, and we're talking about the resort payment, not the maintenance payment. Now, as soon as you stop making your payment, they will refer you to a collection agency. The collection agency will, if you know anything about collection agencies, the way they collect their money is to make the life for the alleged debtor so difficult that they just end up paying the debt, the alleged debt, just to be rid of the collection agency. When you have an attorney involved, they cannot contact you. They must contact the attorney, and that takes away one of their biggest weapons. But let's talk about the question that you raised. I can't afford an attorney, and I can't keep making my payments. Can I stop making my payments? And of course, the answer is yes, you can. What are the ramifications? Your credit will most likely be impacted. They will report to the credit reporting agency that you're not paying. If that's an accurate report, your credit score will drop. If your credit is important to you, it may impact your ability to get credit, particularly real estate-based credit, new lender credit. It is going to definitely impact it. So before we advise a client, and we meaning Fin Law Group, before we tell a client, well, you should stop making your payment, we question them very carefully about their credit, try to determine how important their credit score is, because that is probably going to drop. And we examine that and determine whether or not that's not a lesser of evils. So if you keep paying them, we're going to have a very difficult time negotiating a termination. If you stop paying them, your credit score is going to drop. Is that something that you can tolerate? How important is your credit to you? Do you have a lot of other existing creditors that will continue to extend credit to you? So it becomes a rather complicated issue, and I'd like to give you a really clean-cut answer, but it's just something that we have to evaluate on a case-by-case basis. We like to come to the conclusion that the person can tolerate the drop in the credit score, and we're very careful of sharing with people that that is going to happen. If they're about to make a significant purchase, we may recommend that they don't hire us until they make that new credit purchase, because if that's important, that's something that they should do. So that's an issue that we have to look at very, very carefully on a case-by-case basis. Again, I know I made the answer more complicated, but going back to your basic question, what happens if I stop paying? I don't have a lawyer. You're going to be contacted by a debt collection agency. You could potentially be sued. If you have an attorney, the chances of getting sued are much less, because particularly a law firm that the resort knows is skilled in representing timeshare-based clients. The chances of getting sued is lessened. It's not completely negated. They can still sue, but the chances of that happening is a lot less. So it's hard to give you a crystal clear answer without a case-by-case analysis, Irene.
Well, but you're referring to loan payments, and Destination Timeshare just mentioned I opened with Harborside of Marriott, but we're talking in the case of this person that they only have maintenance fees. And Harborside, the maintenance fees, because it's in the Caribbean and they've had a lot of weather-related damage, her maintenance fees are $6,000 a year. But to default on maintenance fees, to pay someone $13,000 for that is ridiculous. So the difference between defaulting on a loan, and I've followed many people that defaulted on loans. We kind of, I sometimes say we have attorneys waiting in the wings. You might want to just, take your chances and see what happens. I tell everybody my ICE agent story, where when the collection agent called, he said, "I'm so glad you called." Now, how many people would say that to a collection agency? He basically turned the predator into the prey and kept him on the phone for so long. The collection agent was trying to get away from him. So defaulting on maintenance fees, have you heard, you mentioned in a Kiplinger article we were both interviewed for, that some Caribbean resorts were actually trying to legally pursue people for defaulting on maintenance fees.
That's very true. And you can be sued for maintenance fees. It happens more rarely because you have a different entity. You have the homeowners or the property owners association that's in charge of collecting maintenance fees as opposed to the developer. And they're typically a lot less aggressive in pursuing their remedies. However, there's been a couple of resorts in the Caribbean that have gotten very, very aggressive about pursuit of maintenance fees, possibly because they had a lot of hurricane damage and possibly because they really needed to collect that money desperately to fix their resort up to keep operating. And desperate, if you're desperate, you're going to do things that maybe you might not do in a situation where you're less desperate. In those cases, people were sued and judgments were entered in a foreign jurisdiction, Virgin Islands, the Bahamian Islands, and then the judgments have to be transferred to the location where the debtor is located, and it has to be pursued then within the state that the debtor is located. So it's complicated, but to your point, it has been done.
Have any of the U.S. developers tried to sue someone for past due maintenance fees?
That's a good question. I'm not thinking of any that have, again, because it's not the developers who have an interest in the maintenance fees. It's the property owners associations, and by law, they have to be two separate entities. Now, you and I know, Irene, that they're closely related because the property owners associations has a management company that is probably developer owned or at least developer controlled. So you know that it's hard to tell sometimes whether you're dealing with the developer or the property owners association. But the law does make a distinction. They are two separate entities, and property owners associations typically are not as aggressive about trying to collect money.
And the very word foreclosure has been bantered about a lot, and I keep telling people about when you sued Blue Green, Experian, and Equifax, and they had to explain why it should not be called a foreclosure especially it should be obvious with non-deeded right to use points, but what I call your grandmother's timeshare, where we had unit 58, we checked in, you could see, feel, and touch it. if I default on that, is it a foreclosure? Is it charged off? Is it settled for less? Why is it even called foreclosure?
Well, in the case of your grandmother's timeshare, and by the way, I own one of those timeshares. It's a deeded timeshare, and that's a product that hasn't been sold, certainly amongst the big developers, in many, many years. But there still are many deeded timeshares out there. I happen to own one. And if I defaulted, they would have the right to foreclose. Foreclosure is a legal term. It means that a court filing has been initiated, and it's a complaint, just like any other type of civil proceeding. And you're in the foreclosure process. The property is taken away from you if you are successfully sued, and you probably will be because you don't want to keep paying for something that you're not using. And then the property is put up on a foreclosure sale. An amount of money is collected, probably not very much in the case of a timeshare. Usually the developer bids $100. So that $100 is deducted from your balance due on your payment, on your mortgage payment. And it is a mortgage, and it is real estate. And yes, there can be a deficiency that can be entered against you for that. So it gets very complicated. And to your more recent point, Irene, the properties that are not deeded, and most of the properties these days are not deeded properties, the term foreclosure should not be used, because the foreclosure is by definition the taking back of a legal title, and you don't have a legal title when you don't have a deed.
And with the case of Blue Green and the lawsuit where Blue Green had to remove 11,000 foreclosure from 11,000 accounts, Blue Green has some deeded properties and they have right to use points. So did that apply to both sides of the equation, that lawsuit?
It's very convoluted because Blue Green, even though they have deeded properties, the deeds are normally exchanged for a beneficiary interest in a trust. And then the trustee, and we're going to get into this, I think, with some of the other questions that you might have for me, and I can elaborate more further then. But for the most part, as soon as you give your deed to the trustee and take back a personal property interest as a beneficiary, you no longer have a deed, and you're in the same position as if you had bought what they call a right to use property where there never was a deed. And that was the case with Blue Green. There were deeded properties that had gone into the trust. There were non-deeded properties. And our argument was, you're inaccurately calling it a foreclosure. You never filed a foreclosure. And therefore, and the term foreclosure is deadly in the credit reporting business, because you're not going to be able to get a mortgage on any type of new home or any type of a refinance for years and years and years. And Blue Green, I hate to accuse anybody of doing something intentionally to intentionally harm somebody. So let's just call it a horrible mistake. They insisted on calling it a foreclosure. It was inaccurate. We went after them on the theory that this was not a foreclosure, and we were successful, and they were forced to remove the term foreclosure from approximately 11,000 different credit reports, which made a lot of people very, very, very happy who were trying to refinance their homes.
Now, going forward, is Blue Green today calling defaults for foreclosures?
No, ma'am. They have a long memory.
Well, and you would think that would be a precedent for all timeshares, but Westgate is, and we actually had a caller within the last week. She's going to be an upcoming guest, where at her Westgate presentation, it was 17%. And he said, you'll be able to go to your bank and do this right away so that you don't have to pay 1 month interest to Westgate because it's the same as a home mortgage loan. So you just go to your bank and you tell them you want to get a mortgage loan for your Westgate. And of course, the two institutions said, I'm sorry, it's an installment loan. And, so that's not 7%, that's 13%. Now there's two things, I don't want to lose my train of thought here, but you use the word trust. And I've heard over and over, people think that's such a warm and fuzzy word. Diamond points are trust points. But the person that buys non-deeded right to use points, they don't have anything to do with that trust, do they?
Yes, they can. Well, no, I'm sorry. Let me correct what I just said. If they buy non-deeded points, could those points be placed into a trust potentially? I guess it's conceivable, but that's not what's done. So to be accurate, when I answer your question, that doesn't happen. It's going to be a situation where you think you're buying real estate. You're talked into buying real estate with a deed, and then as soon as the deed is presented, they tell you, but if you take this deed and place it in a trust, you'll be a trust beneficiary. The trustee will hold the deed for you. You'll have all of the rights of possession that you would have if you were a deed holder, and it's a much more flexible program. You'll be able to stay in more places, and it's just better for you. And most people give up the deeds and put it in the trust. So the question's a complicated one. Did you ever have a deed? Maybe for a minute or two you had a deed, but you never really you signed it or had it presented to you, and it was immediately taken back off the table. So did you have a deed? Maybe for a minute.
Well, this isn't more the buyer putting it into their trust, but what they're calling them trust points that the buyer is involved with the trust. And what I thought I understood was that the actual brick and mortar is in a trust, but the developer issues non-deeded right to use points. Is that correct?
Fair. That's fair. Yeah, and that probably is not something where a trust would be used by the developer. It's complicated, as a lot of this legal stuff is. But to your point, I think your explanation is the most simple. It makes the most sense. Let's stick with it.
That's because I have a simple mind. Now,
come on.
This leads to the big debate at the appellate court on April 18th, and I really thank Carl, Westgate buyer Carl, and Army active duty Taya, who attended oral arguments in Westgate versus Steins. Is it real estate or is it not? Now, we've kind of partially answered that question, and I think if this lawsuit was, Wyndham, that are just really issuing non-deeded right to use points, but because it's a Westgate is the defendant in this case, it becomes a little blurry whether Westgate is real estate or is it not. So I guess we could call your grandmother's timeshare real estate based on your explanation, but it's just confusing when they have some non-deeded and some deeded.
Well, let me confuse you still further, and tell you that Westgate in particular uses something called a floating deed. A floating deed is an interesting legal invention. They create a deed so that you are pretty sure you're buying real estate, and all of us know that real estate appreciates in value. So this must be worth what we're paying for it. It's a marketing tool, but it's a floating deed, and it's a deed that doesn't specifically give you rights to any one specific unit. It'll make reference to a floor that a number of units are on. What is a floating deed? I don't know. A deed that floats as opposed to one that sinks. I don't know what it is, but they've certainly gone over and above to try to create a product that they can still call real estate. And, we lawyers have an expression, bad facts make bad law. And Nick, who just popped back in over there, may have a comment at this point in time. He may be able to clear this up for us. But it's a mystery to lawyers, certainly myself included, and it's got to be a mystery to all of the people out there trying to understand exactly what the heck we're talking about.
Yeah, I'm assuming most of the lawsuits are based on contract law, not based on real estate law, because it seems to me they have a contract to purchase points. But here's the question I have, being in the financial services industry also as well, or at least working with them for nearly 40 years, Mike. It's the timeshare salesman, since we've had them on, or at least discussed them. Do you know what their contract is? In other words, let's say I want to go work for a timeshare company, and I get paid a commission to go work for the timeshare company to sell timeshares. What is the commission rate that I receive? Or were you ever able to find that on Discovery? The commission rate that I receive selling you or Irene a timeshare. Do you have any idea what the commissions are in this industry?
It varies based on the resort. Let me make the point, first of all, Nick, that these people that are selling these timeshares are probably not employees. They're independent contractors. Most of them are required to have real estate licenses, interestingly enough. It's unlikely that they're going to be employees. They're independent contractors. That doesn't change your question, how much are these people getting? I've heard between 10 and 30%, depending on the situation. If it's something where they really want to provide a huge incentive, property that's not moving very quickly, they want to incent these people to sell the heck out of them, they'll probably pay them 20 to 30%. If it's a property that sells easily, where you're reduced essentially to being an order taker, if you pardon the expression, you're probably going to be in the 10 to 15% range. But it does vary.
Yeah, and I'm assuming also that all the people that buy them are represented by attorneys at the purchase, or maybe they're not and they're operating as their own lawyer. And I've never gone so far as even doing a contract. I've been a lot of the junkets, but I just could never pull the trigger. But if I did, I'd like to look at the contract. Do these contracts have attorney's fees clause for prevailing parties or not?
Yeah. Yes.
Yeah. Okay. So what happens is that person who buys it is at risk. If they don't have a good legal argument, they pay the attorney's fees on this case. Would that be correct, Counselor?
That is 100% correct. And it can be very scary, as you can imagine.
It is big. The other thing is choice of form. Do the timeshares have certain choice of jurisdiction? What I find that can defeat a lawsuit very quickly is we litigate all the cases that we have in Portland, Maine, or Fairbanks, Alaska, or some case like that, or in their case, in their favorite jurisdiction. Do they have choice of forum clauses in there?
Yes, they do. They have every clause known to man or lawyer that it is favorable to them. And I'm glad you brought that up, Nick. And let me just backtrack for just a second. I don't mean to cut off your questions. Irene had asked about arbitration, and that's one of my points is arbitration in and of itself is not a horrible tool. Sometimes it's easier, less expensive, and less time expended on an arbitration as opposed to litigation, and that's not a bad thing. But the clause that you are now referencing, the selection of forum, you probably are going to have to arbitrate or sue that resort in their own backyard, in their own state, in their own county. And that's what makes it more complicated. The arbitrators, in the example of arbitrators, they're going to be selected by the parties. And these arbitrators are going to learn very quickly that if they rule in favor of the resort, they're going to be selected for more arbitration panels. If they rule for the consumer, this consumer is a one-time shot. they're never going to see that consumer again. So if you're an arbitrator that's trying to make a living being an arbitrator, I hate to say it, but who's going to get the edge in that case?
Right. So the thing is, there's a potential conflict of interest when it comes to the when you're doing arbitration. Now, another question I have on these contracts, which I've never seen before: do I, as a consumer, have the ability to negotiate these clauses out or change these clauses? Or are they what they call adhesion contracts? This is the contract, take it or leave it. Can I negotiate these clauses? What?
I'm sorry, I didn't mean to interrupt your question, but I wanted to jump at the answer you offered. The adhesion contracts. These are pre-printed contractors. This is a today only deal. You did not bring your lawyer with you to the timeshare presentation. You didn't bring your accountant. You didn't bring your realtor. It's you against the timeshare salesman, and they are armed with every psychological trick that there is. And when you sign it, it's a fill in the blank contract. You have no ability to negotiate anything.
Well, and I want to add, Nick, that not only can you not talk to a lawyer, but they'll give you a proposal for $180,000 worth of points. And at the bottom, it says you are not allowed to show this proposal to anyone outside of Diamond Resorts. Can you imagine getting a contract to sell your home and being told? And then when we talked about commissions, in residential real estate, 6%, and that includes your real estate agent marketing it for you and advertising it, whereas the resorts charge up to 50%. That includes the 20 to 30% that Mike referenced for the actual commission. And Nick brought up before, when you buy a house, you know exactly what the commissions are. Why are the timeshare contracts not disclosing what that sales agent is being paid?
Because they don't have to.
Yeah, that answers that.
There's no legal requirement that provides commissions. So the thing is, okay, now also, don't we have a little bit of a problem that people are signing contracts, probably as we're speaking today, that can affect their credit for the rest of their lives or for a long period of time without assistance of counsel?
Absolutely.
Especially these people, to my knowledge, at least when I went on a couple of them to, it was Hilton Head, it didn't seem to me any of them were represented by counsel at the time of the negotiations.
If you were represented by counsel, you wouldn't be given the presentation. They would escort you and your lawyer to the exit.
Oh, so that's the reason I got dismissed every time I went to these.
There you go.
You know, they want to know what you do for a lawyer. That's why I'm an attorney.
Once they find out you're a lawyer,
I sue timeshare companies.
Yeah,
I don't sue timeshare companies. But
well,
anyway,
actually, I did receive about a year ago 3 phone calls in a week, and all 3 were lawyers that had been duped by the same developer. One was a consumer protection attorney in California. One was a Michigan state enforcement lawyer. So I always want to advertise Doug Shadell's AARP book, Outsmarting the Scam Artist, where no one is smart enough to outsmart a scam artist. Now, one of the most important things I want to bring up is we had Howard Prosnick on before, an attorney, and in one of his complaints, he said he referenced the oral representation clause, where the buyer signs that they did not rely on anything and rely on any oral representations, which TARDA wants to lobby should be disclosed at or prior to the presentation, not buried in 80 pages. But when Howard made the statement, that is not the law. And I can't remember how he answered, but the oral representation clause, it's not law, but it's in the contract. So that's why it's upheld.
So let me take the first bite, and I bet you Nick will have an opinion on this as well. It's the oral representation clause is a clause that is perfectly lawful. It's used in contracts involving large corporations where the 2 negotiating companies have lawyers. They know what they're signing. Everything has been explained to them. Everything has been negotiated. And you want to make sure that the other side doesn't come into court in the middle of a lucrative contract and say, Judge, I really didn't understand what was going on. I was poorly represented. I want to get out of this contract. I never understood it. There was no meeting of the minds. Those clauses are totally legitimate clauses when you have two entities with lawyers with equal bargaining power. But when you have a timeshare resort with a lot of lawyers who has prepared the contract, pre-printed, the consumer has no representation whatsoever to argue that a non-reliance clause should be part of that contract is absolutely ludicrous. It should not be. But because it is in there, the other side is going to be arguing, Judge, my timeshare salesman never said that. And he's here to argue that he never said it. He'll tell you under oath, he never told the person that. But even if he did, this person signed a contract that said they didn't rely on anything that salesman said. That's very, very strong. That's a very strong legal argument. So I respectfully disagree with Howard's opinion.
Well, I want to point out something because I've been involved a little bit in this kind of scam, and one of the things that is interesting to me is how long the sales will take. I mean, they hold you hostage for hours. You're hungry, you're dehydrated, you're thirsty. You just want to go on your freaking vacation that you paid for. Lots and lots of money. You know, time is money. And then, somehow or another, they turn you over, right? They get you to your mind to click. But 3 hours of sales pitch, it takes literally less than 15 minutes to go through a contract that is 100 pages long in legal mumbo jumbo. They say, sign here, sign here, sign here, sign here. In less than 15 minutes, you sign away your life and you are in prison, locked in prison forever with no way out. No way out. There is absolutely no way out. You can pay thousands and thousands of dollars to attorneys, to timeshare exit companies, but there's no real way out, even if you die. So I just think that it is a life-term imprisonment when you read these contracts, and people don't. The other thing that caught me off guard, and Nick, I just want to let you know, even judges, I was told by the district attorney's office, don't feel bad because even judges, police officers, law enforcement, FBI agents have all been entrapped in these schemes. And one of the things that they have done recently is they are pitching that they're selling you points so that you can use them at the, normal properties like, Hilton. They use the name Hilton as if it is actually the Hilton hotels, and it is not. There's two different entities. But yet they advertise, and everything in all the paperwork and all of the demos they show you, Hilton label is everywhere, and it's so misrepresented. But you're right. You sign this little section that says everything that I was told and heard and shown and demonstrated has nothing to do with this contract, and that should be illegal. That just and this foreclosure situation, that to me is nothing more than a Ponzi scheme, that they can take your property and sell it to somebody else, and you get absolutely nothing back from it. Yet in a real foreclosure, they at least the debt is free and cleared, and you will get you're done. But you're not done with this. You still owe the debt on it. And the way they entrap you on this is they have you use your credit card too. And if you don't have a credit card with enough, they give you one without even checking your credit. There was no way they checked my credit because I had no earned income for 2 years when they scammed me. So I'm just saying there is a lot involved that the law enforcement and our legal people who allow them this right don't even pay attention to. But I think this is bigger than a Ponzi scheme, bigger than a Ponzi scheme.
You know, there might be a new legal argument coming down the pike for the timeshare litigants to come out. And here's how the legal argument goes. If they're using money from their retirement funds, okay, ERISA funds to fund these things, and they're not disclosing their commissions that they're receiving, it may be a breach of fiduciary duty. So there's no cases on it because the Department of Labor has just passed the regulation. It's not effective till September 23rd of 2004. But, and again, I don't know how many people buy timeshares using IRA funds or using funds from their
A lot of
retirement.
them.
Really? But this may be
Yes.
what I call an argument, Irene, an argument de novo before the court, because since we administer a lot of qualified plans, the Department of Labor fiduciary rule is now being installed on anybody who touches these funds. So if you have a retiree who's touching these funds, or somebody who's pulling money out of these funds without disclosing their commissions and without going through the proper fiduciary rules, they're held to be in violation of a prohibited transaction under ERISA, under federal law. With that, I'm going to say this show is for educational only and not for legal advice. For legal advice,
That's
consult
right.
your own attorney. The reason I'm doing it verbally is that sometimes we're on radio when iHeartRadio and Spotify carry us, and they don't see the disclaimer rolling underneath there. But I think we'll live in interesting times when because like what you say, Irene, a lot of the retirees come in and the salesmen are looking where to get funds. Well, I have money from my IRA. Perfect. Not perfect anymore. It might be a DOL violation, Department of Labor violation, unless they go through the proper procedure of disclosing their commissions they're receiving prior to the sale and contemporaneous. And I believe, because it's so new, this DOL fiduciary rule, that it has never been litigated, but watch. Some attorney will throw that in there, especially if the client comes to you and say, well, I used my retirement money to buy this. Bingo, down you go. A DOL complaint comes down. So I think we're going to see that to be quite interesting, because we know the retirees have the money, but it doesn't necessarily mean they're spending it correctly on their retirement, or they're investing in the proper channels. And I don't think timeshare is really a great investment for your retirement funds, but that's my opinion.
It's
Yeah.
a
I'll
horrible,
throw it out there,
I
Mike.
agree.
So
it's
maybe you'll go
a
to better-
horrible investment. You're buying something that you can't
It's
sell for
not
a nickel.
Okay,
It's
but
not an
wait a
investment.
minute. Let's look at the flip side. Why have I not had an attorney or any complaints through TARDA about Disney Vacation Club?
Is that
because you
question
can't
for
attack
me?
Mickey Mouse.
Yeah, you're. I don't think Nick's had marketed has helped anybody get out of any timeshare.
I have never had a Disney client. Never. I've had every other resort imaginable. I think everyone practically on the planet. When we've been contacted by potential Disney clients, our first question to them is, have you called Disney? Well, no, you're a lawyer. I called you because I'm mad at Disney. Call Disney. If you have a problem after you're done talking to Disney, call me back. I've never gotten a call back.
Well, let me ask
Exactly.
you this: is
They may
Disney's
settle.
vacation club managed by Disney? Like
Yes.
officially, it's
Yeah.
Disney
Yeah.
and Disney. It's not
Yes.
Hilton,
No.
and it looks like Hilton, but it's actually Hilton Vacation Club.
It's not two separate sock symbols.
There-
Right.
there
But
may-
it was a
there-
rhetorical question, because I can answer why. And number one, it does have resale value. And there
Yes.
are people that have resold it for more
Yes.
than what
Wow.
they paid for it.
Yes.
The second is they did not deliberately suppress the secondary market.
Yes.
So you can easily sell it. Wyndham and Diamond Resorts, when Diamond was a publicly traded company, both had in their annual reports, a viable secondary market would be a risk to our stock and bond investors. And as I've said on a prior show, can you imagine Lennar or Pulte home builders saying as a viable secondary market would be a risk? And the other, even Disney allows you to rent. I mean, if they say you own your timeshare, but you can't rent it, you can't stay in it whenever you want. It's really, but what we're now that kind of leads us into a topic I know it's going to take a little bit of time, so I don't want to miss it. Is Mike's favorite topic, exit companies.
Oh,
So
I just love exit companies. Well, first of all, they're my competitors. So please take what I say with a certain grain of salt. If you're saying bad things about your competitors, you may have a financial motivation for doing so. So with that caveat, let me go on to say they are unlicensed. That lawyers are licensed. They're unregulated. Lawyers are regulated. They are doing things that only lawyers are permitted to do. Negotiate a termination of a contract. That's a lawyer's job. The people that own exit companies, almost every one of them is a former timeshare salesman. I'm sorry, but that guy got me into trouble to begin with. He probably isn't looking forward to getting me out of trouble at the other end of the spectrum. So do I think that exit companies should not be operating? Absolutely. I have no explanation for why they are allowed to even be out there, and yet there they are.
well, I
I
think
think they are associated with the timeshare companies because I found it very interesting how immediately I started getting phone calls from the exit companies when I started filing questions and complaints and everything. Immediately, somebody called me from an exit company. Now, thanks to, and I'm not advertising for him, but Dave Ramsey, I always listen to him when I travel. And he was doing a show on some of the timeshare stuff. Apparently, maybe someone he knew got hooked into it. But he said, absolutely do not use a timeshare exit companies. They are nothing but a scam. Please, please call a real litigated attorney and someone who's familiar with the
well,
timeshares.
actually, that's incorrect. Dave Ramsey endorsed Timeshare Exit Team and received
Did he
millions
really?
of dollars, and he's been sued for $150 million by his fans for recommending
Wow.
Timeshare Exit.
Why does that not
No,
surprise
so
me?
he advertised the exit companies, and at the same time, literally,
Yeah,
I was
don't
driving
use
down the
them.
road.
Don't use them unless they pay me. Then they're great and wonderful
Right.
to use.
Oh my
Well,
gosh.
Sounds like a Dave
I'm
Ramsey
off.
move.
I will never listen to him again. Ever. Oh my
well,
That's a
gosh.
Dave Ramsey move if I ever saw
let
one
me
on the
let me
chessboard.
give you a little history, though. In the beginning, I sound like the Bible. These they did have some success. Timeshare Exit Team did have some success. Timeshare Compliance did have some success, and it's kind of a self-advocacy like we do. But then the developers all kind of sit around a table like the mafia dons, and they all say we're going to ignore exit companies. And so I attended a 5-day trial where they had sued an exit company and a law firm affiliated with them. And they would even ignore the attorney's cease and desist letter. So I don't know how they could ignore that, but I guess so then what do you do? And one of the problems is the exit companies will say, these are one of your 5 choices. But if they know beginning in 2018 that Wyndham was going to completely ignore them, should they not have informed their customers that likely your only option is going to be to default? And they say you don't have to pay anybody to default. But the problem with that statement is a lot of the people that contacted me are in their 60s, 70s, 80s. There's never been a bill they haven't paid. They'll probably never sleep again if there's a bill they don't pay, and they need support with that foreclosure process. So, and I will reach out to the people I know from the exit companies. They hear from me when I say, hey, you have a 2-year money back guarantee. It's been 3 years. You need to give them your money back. I will reach out to the ones I know and give them equal time on this show so we can hear what they have to say. Oh, and one thing that really bothers me is Westgate, and I think other timeshare developers are requiring an affidavit that if you are released and you're contracted with an exit company, you have to sign an affidavit under threat of perjury that you have not retained a third party. Now, and Westgate has sued their owners or former owners, asking to accelerate the note and pay attorney's fees. So I don't see how they can even operate. They're saying, well, it's up to the person if they want to sign that or not. What do our lawyers have to say about that?
We have one of those. We have one of those cases, and it's the exit company in question, and I'm not going to mention who it is, has put these people in a terrible situation because they made them sign a affidavit, which, as you point out, is a statement under oath. You're required to sign an affidavit saying that you never had any contact with an exit company. You did have contact with the exit company. You did what the exit company told you. The resort knows that you contracted with the exit company because the language from the terminology that is sent to the resort is the same in every situation. So they know who's using an exit company, and they can go after you for not only will they not let you out of your resort, but they can go after you for whatever damages that they can argue that you have created for them. And you're a perjurer when you're sued. We have such a client.
And you could even be sentenced to jail time for perjury, can't you?
Yes, that's probably a stretch. I would say in this particular instance, it's civil. It's not criminal. If it was in a legal setting, absolutely, it's a crime. In this situation, it probably is a crime. It's probably a misdemeanor. No prosecutor is going to prosecute that case. But the point is to take your customer and make them a perjurer so that you can make a buck. I mean, who does that?
Well, and then
Exit companies, I have the answer to the question, Counselor. Exit companies, they do it. Well, I just don't know why anyone would hire an exit company rather than hiring an attorney. As general counsel from our company in Salt Lake, I hire a lot of attorneys from some of the largest ones like Ropes and Gray and Preston Gates and Ellis, all the way down to small individual practitioners. But the reason why is you bring the legal power to the table. I'm not sure if exit companies bring anything to the table. They're just some person who's barking. I don't get, if you want to get out of this, you should hire a lawyer, not hire exit company. Even some of these other things I do, always go hire an attorney. I do not hire these outside individuals. I don't know why people would do that. So Irene, I don't know if you have people hiring exit companies, but in a legal matter, I like to hire lawyers. I don't like to hire John down the street who talked about law at Denny's, and thinks he knows a lot about law because him and his buddies get in Denny's and they talk about legal issues. At the end of the day, they don't have the power to file a complaint on my behalf. So why bother with them? I don't get it.
Well, basically, they're doing the same thing our volunteers are doing. When people call, they don't know where to turn. And
Sure.
Even highly skilled professionals.
You got somebody right here. This is what he does for a living. He's done it for 15 years, 20 years. Call this guy.
Yes. Well, people, they can't,
He's
they
not
don't,
phone or an email.
they don't know how to.
Here it is, Mike. Destination Timeshare. They pay a lot of money for advertising their services. So what Destination is saying, you need to pay Google to get high on the search engines. There we go.
Well, and I researched Destination Timeshare, and I'm going to insist he become a guest on our show sometime because as I check everyone out, he's charging a very small amount of money for just kind of resources on how to best use your timeshare, if I understood his site correctly. But yes, absolutely, they pay a fortune for advertising, and but I do know some that are really working hard. They do basically what our volunteers do for, we're volunteers, so we don't charge. It's a whole different path, self-advocacy, where most of the time they will not disclose that they have retained the third party. So they're doing the work themselves, and they will just give them a template or guide them in how the very first step, whether you're a law firm or you're a volunteer with us, is a clear, concise complaint. And people just call and they start talking, and when you tell them, can you write down what happened, they're like a deer in headlights. First of all, they're so frustrated and so angry, but I think that it's really hard for me to I consider an attorney as a last resort. So basically, the first step is the clear, concise report, and then sending it directly. Now, one thing attorneys don't do, and correct me if I'm wrong, Mike, maybe they do, file complaints with the attorney generals, with the Federal Trade Commission, with the Consumer Financial Protection Bureau, because if people don't file complaints, then you don't think anything's wrong. So
we do it.
You do? Okay.
We do it, absolutely.
Yeah. And do you think the Better Business Bureau is much help?
Yes, they can be. They can be some help.
Yeah.
We've worked with a couple of them that have gotten very, very active and very involved. Most of them, candidly, they can be. It's a money raising business. They're not a regulatory agency, and most of them can be persuaded to change their. Well, I don't want to get too much into this. They're not a regulatory agency, but the resorts do sometimes concern themselves with better business scorings. Can the scorings be manipulated? I've seen it happen. But yeah,
Right.
but the Attorney General, the Federal Trade Commission, absolutely, they need to know what's going on. Where are these regulators? Why aren't they pursuing these companies that are taking advantage of people? They can't be asleep at the switch, can they?
Well, they're sending lawyers to the appellate court, CFPB, to argue on behalf of consumers, and they filed amicus briefs in at least 2 lawsuits. So the CFPB is listening, but they're such a behemoth.
They're huge. The ground. Yeah, they cover a large ground, including the securities industry. We're a 2-minute warning, so we're going to have to wrap up basically.
Good, because I have a headache whenever we have the lawyers on, because I'm sitting here taking all these notes and trying to keep up with everything.
Well, we do have a question that did not come through here. We have several, actually, that didn't make it through. But it says, I'm a little behind on how do we even get the message out to never wire money for a timeshare transaction? And then maybe we can wrap from here.
Well, that's what we're doing here. And, you have 2.3 million viewers at Pod TV. So if we can just boost that up to 20 million viewers, I think we'll be really on the road to doing that. So.
That's right. Keep sharing, because we are here every Monday at 1 p.m. You can also check us out on our website, www.podtv.tv, where you can watch her anytime, anywhere, video on demand. Just scroll down to our video on demand shows, and there you'll find Irene's beautiful smile taking on the timeshare. She looks so sweet and kind. Yeah. But boy, don't mess with her.
Also realize we're on Roku TV.
And Amazon.
But remember, when you go to Roku, type in the Pod TV and it will show up as a channel. If you go to the Roku channel, we're not on there. We have our own separate channel along with Roku and Netflix. So just remember, when you go to Roku, type in their search engine Pod TV. Do not go to the Roku channel and type Pod TV. That's Roku's channel. Pod TV has its own channel on the Roku.
That's right.
Search
So when
engine.
you open up your Roku and you can, I think, go to the channel section and look for
Yeah.
us if you're already set up.
Yeah.
But anyway, thank you very much for watching us, for your beautiful questions. We have enjoyed it. We've enjoyed this conversation, and we're going to continue serving the consumers and their rights. And we'll see you next week. Take care, everyone.